Everyone. I hope you're having a nice day so far. This lecture is on Chapter 3, the medical, legal, and ethical issues involved with being an EMT. Let's start out with a quick dispatch to set the frame for this lecture and give you something to think about. You are EMS Unit 105. You're dispatched to East 3rd Street for an elderly male with abdominal pain. When you arrive on scene, you're greeted at the door by an elderly female. You look past her and you look down the hallway and you see boxes stacked almost to the ceiling. You see trash all over the floor. And as you make your way past all of the clutter, pushing your way through, you find a male lying on a mattress on the floor, and he's moaning in pain and holding his belly. You get a little bit closer and you notice that his underwear is stained with urine and feces. He smells really bad, and the house is quite uncomfortable and very cold. So what do? How do you proceed? And for this lecture today, I want you to think about this case mainly from the legal and ethical viewpoint. What do you need to consider? Is this a case of neglect? Is this a case of elder abuse? Do you have concern for a physical assault that may have occurred? And what do you need to do about it? What should you do about it? And what options do you have? So just keep this case in mind as we go through. And, these are very real scenarios that we're talking about today. You will be faced with these ethical issues. And I remember a case call that was almost identical to this for a psychiatric patient, where there was just a trail of feces up the stairs and into the bedroom, and feces smeared all over the wall. And we had to take some similar steps that we'll talk about today. So first, let's talk about, as an EMT, what are you legally allowed to do with your training? And the scope of practice is a really important concept to be familiar with. And basically, this is established by state law, and it is the legal framework in which you operate. So when you think about a scope of practice, I want you to remember that this is different than scope of knowledge. You can have a really broad knowledge base. You could even take the class to become a paramedic, or you could have you could have gone to nursing school. But unless you hold those certifications, you have to operate within the restraints of your certification as an EMT basic. So even if you know how to start that IV, or if you know how to stitch up a laceration, you can't do that as an EMT, and you have to operate within your scope of practice. Another term to be familiar with is the standard of care. The standard of care is basically how another EMT with the same training and same experience as you would reasonably treat a patient. And that's basically the minimum care that you need to provide as an EMT. So your scope of practice is technically defined by state law. So here it's North Carolina state law, and the sources that are used to establish the scope of practice come from a variety of sources more on the national level, such as the National EMS Scope of Practice Model and the U.S. Department of Transportation, the National Standard of Curriculum. But in the end, what you need to be familiar with is what your state allows for the EMT. This is just an example of the medication scope of practice in North Carolina, and this is a really standard layout for how these are presented. And you just look for your certification level. So here it's an EMT basic, which just reads as EMT on this, and you look at the medication, for example, acetaminophen or Tylenol, and you can see here it's indicated that is within your scope of practice. If you go down to beta blockers, you see that's only an EMT paramedic skill. And the same types of protocols exist for skills. So you can see here that as an EMT basic, you are allowed to suction, but you are not allowed to conduct a cardioversion. That's a paramedic level skill. So as an EMT basic, you take this course and then you get certified with the state and maybe on the national level. What are your legal duties? What are your legal responsibilities? An important thing to consider is when you have a duty to act as an EMT. One really big distinction is whether or not you're on duty. And this really changes what you are obligated to do. If you are on duty as an EMT, you are obligated to provide patient care when called upon. So if you get a 911 call, you are legally obligated to arrive on scene, complete your assessment, and provide appropriate care to that patient. If you are not on duty, say you're driving down I-40 and you have your little sibling in the back, your little 2-year-old brother, and you see a car accident on the side of the road, it looks pretty bad. There's no one else on scene yet, it just happened. And you think about stopping, but then you're like, well, I've got my 2-year-old brother in the back, and it's really not safe. It's a busy day, and I don't feel comfortable pulling over. What is your duty at that point? Can you keep driving? Do you have to pull over and help? And the answer is you do not have a legal obligation to act. You are off duty. But you need to keep in mind that if you were to pull over in that same situation and start to provide care for that patient and then change your mind and said, oh wait, this doesn't, I'm late for dropping off my little brother to daycare. I need to go. At that point, you do have a duty to act. You initiated care. You made contact with that patient. You need to follow through and transfer care of that patient to an appropriate person with, equal level of medical training or someone with greater training than you. You have a few other duties just to consider, as an EMT. First and foremost, you have a duty to your patient. You really need to respect the rights of every patient that you encounter and advocate for them and really do what's in their best interests. You also have a duty to yourself. You need to make sure you have the right credentials. You need to make sure you maintain your skills and your knowledge. And then that you're mentally healthy every day, you show up for work, and you're physically fit to perform your duties. And then similarly, you have a duty to your partner to be mentally fit, physically ready, and to perform the responsibilities of your job. And then lastly, a duty for your equipment. You need to make sure your equipment is in good working order, you know how to use it. Every day you show up so that you can do your job. So one question you might have is, okay, so say I'm off duty and I'm driving down 40 and I see that car accident and I pull over to help. What happens if that patient has a bad medical outcome? Am I going to be held liable? Am I going to get in trouble? And you should be familiar with a protection you have as a citizen, and this applies to any bystander, called the Good Samaritan laws. And these were originally enacted in 1959 in California. These protect you if you provide medical care in good faith while you're off duty, and they don't prevent you necessarily from getting sued. People can always sue you for whatever they want to, but in the court, after you get sued, they will protect you from liability. And if you're acting in good faith and you weren't grossly negligent, you won't be found responsible for any damages. Now, the key here is that you can't be grossly negligent. You can't do anything that is below the standard of care, which, again, remember, the standard of care is what would a reasonable EMT with the same level of training and the same level of experience have done. And if you meet that standard, then you're fine. And then, obviously, if you did anything to intentionally harm a patient, you are not protected by the Good Samaritan laws. There's a few other legal protections. I just want you to be familiar with these terms and generally what they mean. Sovereign immunity is something that protects government EMS agencies. So if you have a county EMS agency, this prevents patients treated by that government agency from suing or holding them civilly liable. This does not apply to private EMS agencies, private transport agencies. This protection is not for them. And then statute of limitations, this is the amount of time a person has to file a lawsuit or a claim in the civil court. And this is typically in the form of years, and it varies depending on what they're suing for. Every tort has its own statute of limitations associated with it. And then contributory negligent is essentially a term saying that if the patient contributed to the damage that they're suing you for, then they do not have essentially the right to sue you for that. You will not be held liable. So as an EMT, you operate every day, if you're working for an EMS agency, under the direction of a medical director. And the medical director is a physician, and you operate under their license, and they're responsible for creating the standing orders. And the standing orders are things like, you can administer Tylenol for X, Y, and Z. You can administer oxygen for X, Y, and Z. Things that you can do without having to call and ask permission. And they establish the protocols, and then they're also available for communication should you have any question while working. And it is always important to remember that as an EMT, if you have any questions about the direction that care is going, or can I do this, or should I do this, you can call your medical director. You don't call for simple things, things that are standing orders or within the protocol, but if things get complicated and you need some more guidance and you need help, you can always call your medical director. And we already talked about this. So we talked about the legal responsibilities you have as an EMT and the protections, but you also have to consider, what are your ethical and moral obligations as an EMT? Ethics is considered a branch of philosophy that specifically is related to the study of morality or morals, and then morals are the actual concepts of right and wrong. And then, as an EMT, you do abide by a code of ethics, or what the National Association of EMTs has called the rules of ideal conduct. And basically, if you show up with good intentions to every call and with the patient's best interest in mind, then you'll be just fine. But let's just run through these real quick to make sure you're aware of them. So first and foremost, like I said, the patient is your first priority, and place their welfare first. Respect all individuals that you encounter, no matter who they are, and treat everybody equally. Maintain your knowledge and your skills so that you can complete your assessments and administer treatments correctly. And always make sure that you're thinking about the calls that you went on. You're reviewing what you did and thinking, was that right? Is there room for improvement? And what would I do next time? And then always act professionally. Complete documentation honestly, and make sure you keep all patient information confidential and don't violate anyone's privacy. And then lastly, just work well with your coworkers, your fellow EMTs, and all the personnel at the hospital. All right, so let's go through a quick case study. This is going to be, I guess you could say, an ethical dilemma I want you guys to think about. You respond to a patient who's had fever, nausea, vomiting, and headache for 2 days. She recently lost her job, and she has no health insurance. She has 2 young children at home that she's the sole provider for. And the reason she called EMS is because she can't afford to go to her primary care physician, and she just wanted to get checked out. You complete your assessment and you determine that she doesn't need to go to the hospital. And she asks you for some ibuprofen for her headache. You agree with her, you think that ibuprofen would be an appropriate treatment. But then you remember that if you document this and you give her the ibuprofen from your ambulance, she'll get a $200 bill. If you don't give her the ibuprofen, then all you did is the assessment and the visit's actually free. So you decide, you give her the ibuprofen, and then you falsify your report, and she doesn't have to pay for the ibuprofen. So what do you think about this? Was that an ethical thing to do? Was it moral? And at the end of the day, if your boss sits you down and says, what did you do? What would you expect them to do about it? What should they do about it? You definitely have a conflict here. Ethically, providing the ibuprofen was, definitely in the best interest of the patient. And I don't think anyone's going to argue that $200 is reasonable for, one pill of ibuprofen when, that's probably under $1 if you get that out of a container of pills at CVS. But morally and legally, you really made some major violations by lying in your report. You have to abide by the laws, and you're obligated to truthfully fill out every PCR, every patient care report. You need to fill out accurately and honestly. And then lastly, legally, by lying on the patient care report and essentially evading billing, you could be committing some type of fraud and be held legally responsible. So just remember to always work within the constraints of the system. You need to abide by the local laws. You need to abide by the rules of your agency as well. So when you see a patient on shift, you need to always remember that they need to consent to your assessment and they need to consent to your care. And they do have a right to refuse both. There's a variety of types of consent. We'll go through each one of them. But under the law, if your patient is conscious, they're competent, and they're rational, they have the right to refuse your care. So the first kind of consent is informed consent. And this is basically saying that you have informed the patient of your assessment. They understand it. They have the knowledge to understand what you're telling them. And they understand the risks and benefits of the treatments that you want to administer. And then once the patient is informed, they can either give expressed consent or they can decline care. So if they express consent, then they verbally or in writing agree to your care. And in order to do this, they must be an adult. So in our state, an adult is 18 years old, and they must be able to make a rational decision. They must be of sound mind, and they must be informed, as we talked about. And then implied consent. This comes into play when a patient is unconscious, or they're just unable to make a rational decision. Examples of this would be if someone is intoxicated, if they're on drugs, if they're inebriated, or if they have some type of head injury, a stroke, or a traumatic injury that is making them disoriented and altered and unable to understand the risks and benefits of the treatment that you're proposing. So in these situations, you can operate under implied consent and say, if they were of sound mind, they would have agreed to this, but they're unable to do so now. So you can still give treatment, even if they say, no, I don't want to be treated. You can treat them essentially against their will if they're very clearly unable to make that rational decision. And then if you'll deal with a lot of pediatric patients. The key with these patients is they can't technically consent. Their parents need to be the one consenting for them. So you need to get in touch with their parent or guardian and ask for consent to treat them and transport them. If they're alone, then they fall under implied consent. So if you encounter a 6-year-old who has, fell off their swing set, broke their arm, and there's no adult around, no parents around, you don't know how to contact them, and the 6-year-old says, "Oh, I don't want to go to the hospital," but their arm is an obvious deformity, you have the legal right to provide them with care and transport them to the hospital under the implied consent laws. Now, even if you're operating under implied consent with minors, you really need to make an effort to get a hold of parents as soon as possible. And then involuntary consent is a unique one. This comes into play when your patient is in the custody of law enforcement or has been deemed mentally incompetent, potentially by the state. In those cases, someone else has been deemed to be their decision maker, such as law enforcement or the state, and they're the ones that provide consent for that patient. Advanced directives are something you really need to understand as an EMT. They're incredibly important and often represent, what the patient wants out of their care. And technically, they're a legal document expressing the wishes of the patient. There's a variety of forms that these come in. The most common one, and I guess debatably one of the most important ones, is the Do Not Resuscitate Order, or the DNR. This particular one states whether or not the patient wants CPR if their heart stops or if they stop breathing. This one's quite common in patients who are chronically ill, and we'll talk a little bit more about the details, but must be on scene with the patient. And then the living will, this gets a little more into particulars about what patients want with their care. These often address things like, does the patient want a feeding tube? Does the patient want things like antibiotics? Do they want to be intubated? Things that often are more applicable for the hospital setting, but if someone presents you with a living will, you need to take a look at it, and you need to make sure you bring that with them to the hospital. And then durable power of attorney. This document's important if the patient is unable to speak for themselves. So it designates someone as a decision maker for the patient if they're unable to speak for themselves and if they're no longer competent. And then the POLST form, or in North Carolina, what you're actually going to see is the MOST form, the medical orders for scope of treatment. This gets really down into the nitty-gritty of what patients want, what types of treatments they do and do not want in their care. So this is just the protocol for North Carolina, stating that as an EMT, you are obligated to honor the advance directive. This is what a DNR form looks like, and they look just like this. They're yellow, they're bright. I think sometimes they can be orange too, but they're meant to be, to attract your attention so that you see that they're there. And sometimes patients will have this behind their bed. I've seen that. I've seen it posted on the refrigerator, hanging on the wall. So your responsibility, if you show up on scene and, a patient is coding and the family says, wait, they have a DNR, you need to say, show me that DNR. You need to see the physical DNR. You need to make sure that it has the right patient's name on it. You need to make sure it's signed by the physician and that it's an original copy, and make sure that's valid. And then if it is valid, you need to honor it. If there's any questions about whether or not it exists or whether it's valid, just go ahead and start resuscitation. This is an example of the North Carolina MOST form, and you can look these up online. They're kind of interesting, and I actually highly recommend it if you have any family members that are older. These are really good forms to specify what they want for their future and what they want for their care. We already talked about the living will, the healthcare power of attorney. So let's talk a little bit more about refusal of care. So we talked a lot about, consent, the different types of consent you have to get from a patient in order to legally be able to treat them. But what happens when the patient says, they don't want your care? Well, first of all, they have that right, like we already talked about, and they must be informed in order to make that decision, and they must be competent. So the first thing you need to figure out as an EMT, once they start going down that road and saying, I don't want your assessment, I don't want your care, you need to make sure that they're competent and they're oriented. So this is why those orientation questions are so important. Are they oriented to person, place, time, and event? Make sure they can answer these questions and they truly understand what's going on. Examples of times when you might find through further questioning and in a more detailed exam that they are not oriented or they are not competent, that is if they are having a psychiatric episode, a psychotic episode, maybe they're hallucinating, maybe they're having auditory hallucinations. Are they under the influence of drugs? Do they have a head injury, a traumatic injury? Do they have a head bleed? Are they having a stroke? These are all things that can cause altered mental status and may make them incompetent and unable to refuse care. And remember that, even if a patient does provide consent for you to care for them at any point during the treatment, they can withdraw that consent. So what do you do when they say, I want to refuse your care? Well, there's definitely a list of things that you need to keep in mind. If the patient says, I don't want your assessment, you shouldn't necessarily just stop there. You really have an ethical responsibility as an EMT that if you believe that they need your care, and if you don't provide them treatment and transport, significant harm could be done, you need to convey that to them. So try to persuade them. An example would be, if a patient's having significant chest pain, they look really gray, they're diaphoretic, their blood pressure's in the tank, it's 90/50, and their heart rate is 150, you need to do your best to convey the severity of that to them, be very clear, and explicitly state what the risks are. I fear that if I do not treat you and transport you to the hospital, you could die. And say just that and be very clear. And then ask your partner to talk to them. Sometimes you just don't click with the patient. Maybe your partner will get through to them. If that doesn't work, you can call a supervisor. Have your supervisor talk to them. If you really feel that it is so severe, you can call medical direction and let them know what's going on and ask them if there's anything else that they want you to do. And then if the answer is still no, you need to tell that patient that just because they're refusing care now does not mean they can't call you back. And very strongly encourage them to call 911 back if they change their mind and they want treatment and transport. And then lastly, document. This is so incredibly important to cover you so that you're not held legally responsible later and don't get in trouble if they end up having a bad outcome. Every EMS agency has refusal forms. You fill out these refusal forms. You get a witness to sign the refusal form acknowledging that they heard that conversation and they heard the patient refuse your care. If sometimes the patients refuse to sign the refusal form, if that's the case, then again you have a witness sign it saying that they refuse care and they refuse to sign the form. So let's talk about, I'm going to give you an example of a legal concept and term called negligence. And this is an example that came out of North Carolina in Franklin County. So a Franklin County man was hit by a vehicle on a roadway, and the paramedics showed up on scene, did their assessment, and determined that he was deceased. They called the medical examiner, and the patient was transferred to the county morgue. And then once he was at the morgue, he was actually found to be gasping and had shallow respirations in the morgue and was alive. And he was transferred to the hospital, was treated in the ICU, and he ended up suffering irreversible brain damage. The family, in the end, brought a lawsuit against the paramedics for negligence, and they were claiming that a reasonable paramedic would not have declared him deceased on scene. So that was, one example. It's a very extreme example of negligence. But this term negligence is something that you need to be aware of, and there's two different ways this comes into play. One, if you're deemed to be negligent, you can be held criminally liable, which basically means that the government sues the EMT on behalf of the public, and this can result in a fine or jail time. And then you can be held civilly liable, which basically means that you're being sued for the damages or the wrongful act. And in this case, the typical result is some type of monetary compensation for the damages. Most of these lawsuits actually result from failure to act rather than improper treatment, and negligence is very rarely an intentional act. Usually, you don't intend to do harm if you're being negligent, but you just fail to perform your duties to a reasonable standard. An example would be, if you responded to a rollover MVC and you instructed the patient to get out of the car, took no C-spine precautions, didn't put on a C-collar, didn't put them on a backboard, and then they, as a result, they ended up having a life-changing spinal cord injury. Another example would be not giving oxygen to somebody in respiratory distress with an oxygen saturation of 80. Those are examples of failure to act and negligence. In the court of law, so if once it reaches that level, the courts have to prove that the EMT had a duty to act. So you're on duty, you were dispatched to a call, and that was your patient. You breached that duty to act, and the patient suffered injury or harm that was a direct result of your actions. If they suffered an injury that would have happened anyways or was not a result of your actions, then you would not be considered negligent. So we talked about the duty to act. You respond to the scene, you provide emergency care. You breach that duty to act, and that can be in the form of simple negligence where you failed to perform standard care or make a mistake, or in the extreme cases is gross negligence. You willfully and recklessly provide improper care, and that's the one that can lead to criminal charges. Remember, we talked about what the standard of care is. It's the care that's expected of you as an EMT as compared, how would another EMT with similar training and experience have acted in that situation? And if you don't meet those standards, then you could be considered negligent. And then lastly, remember there have to be damages. They have to be real injuries that are recognizable and can be demonstrated in a court of law. And then you have to have caused those damages. So some other legal aspects that you need to be aware of. One is an intentional tort, and this is an action knowingly committed by an individual that is considered to be civilly wrong according to the law. Negligence is when you fail to meet the standard of care, and intentional tort is knowingly committing a wrongful act. That's the difference here. So an intentional tort, an example would be abandonment. Abandonment means that you don't properly transfer care of the patient to someone with equal training and expertise as you, or more training. An example of this would be if you take your patient to the hospital and the registration clerk says, "Wow, we're really backed up, really busy today." You look down the hallway and there's just patients everywhere. There's no nurses around to take your report. And dispatch calls you on the radio and they're like, when can you come back in service? We need you back in service. There's calls coming in and you're hungry. You want to go back to the station. So you find an empty stretcher and you put your patient on the stretcher and leave the paperwork with the patient and tell the registration clerk, "Hey, I left their paperwork there. They're the third third bed on the right. That's an example of abandonment. You didn't transfer care. The registration clerk is certainly not the appropriate person to transfer care to, and you abandon that patient in the hallway. There's also assault and battery, and you need to just be aware of what these legal terms mean as an EMT. Assault is any willful threat to inflict harm on a patient, so you can actually legally commit assault without even laying hands on a patient if you threaten to inflict harm. So an example of this would be if a patient won't put their seatbelt on, and you ask them nicely the first time, and then the second time you tell them, if you don't put your seatbelt on, I'm going to take this EpiPen, and you pick up your EpiPen, you raise it up in the air, and you say, I'm going to stab you in the leg with this EpiPen. But you don't actually stab them in the leg. That's still an assault. You threatened them harm, they feared harm. And then battery is the actual act of touching and harming a patient. So if you were to follow through and stab that patient in the leg with the EpiPen, that would be assault. A more reasonable example would be if you were to conduct a physical exam on a patient without their consent. So any unwanted touching of a patient, that is technically assault. So just make sure that you're communicating with your patients and you're getting consent before laying hands on them. False imprisonment or kidnapping. This is just another really good example of why you need to get consent for assessment, for treatment, and for transport. If you transport a patient without their consent, legally speaking, that can be considered false imprisonment and kidnapping. Now, just remember that they have to be competent to refuse your assessment, treatment, and transport. So this, obviously it's not considered kidnapping if they're not competent, they're intoxicated, they have a head injury, and you have to transport them against their will under the implied consent laws because they cannot offer informed consent. Now, as an EMT, you really have an obligation. You're going to hear a lot of things. You're going to gain a lot of knowledge about people and really be privy to a lot of personal information that could potentially be damaging to people's character, their reputation, or their standing in the community. So it is your responsibility to maintain their privacy. You can't share this information, what you learned on a call, no matter how funny you think it is or how interesting it is or how famous the person is. You can't talk to the media. You can't talk about patients in public places. You can't tell your family about patient encounters and share personal information or your friends. If you decide to share this information, you damage a person's character, their reputation, it is considered legal defamation and they could sue you. If you do this in the spoken form, it's called slander. And then if you write about it, for example, online, it would be called libel. So when talking about confidentiality, there are times when you do need to share information about patients. So this is when you need to be aware of, your state laws and aware of when it's appropriate to share information about people. One of the big acts you need to be aware of is HIPAA, and you'll hear a lot about this. This is a federal law that is really designed to protect the privacy of the patient healthcare information. It was established in 1996, and it lays out very strict requirements for the storage of patient records, who can access them, who can release them, and if you violate HIPAA and you release patient information inappropriately, not only will your agency be fined, but you can be held personally liable and really incur a very hefty fine. So some of the times that it is appropriate to release patient information, if the patient gives, written release to talk about their care, if you need to provide patient information to another healthcare provider for the continuity of care. Example of this is another paramedic arrives on scene is going to take over care, you need to provide all the patient information to them so they can properly care for the patient. And the same applies for obviously transferring them to a hospital. You need to provide that information to the nursing staff and the physicians caring for the patient. There are special situations where you will have to report information to the state or the local law enforcement authorities, and those can be in cases of abuse, sexual assault, and other crimes as well. And then sometimes third-party billing companies through your EMS agency will have forms you might need to fill out, or you could be subject to a legal subpoena to appear in court and talk about a patient. All those cases, it's okay to talk about confidential patient information. COBRA and EMTALA, these are two federal acts that you need to be familiar with. And the most important one that you need to be familiar with is EMTALA. And these are basically designed to make sure the public has access to emergency health care, whether or not they can pay for it. And big picture, EMTALA prevents something called patient dumping, which essentially means that if they can't pay for their health care, hospitals are not allowed to essentially dump them or transfer them to another hospital just because they can't pay. This also applies to interfacility transfers. So if a hospital is going to transfer a patient from their hospital to another for care, they have to make sure that the person conducting that transport has the skills and knowledge to be able to properly care for that patient. So the way that you make sure that you're abiding by EMTALA, if you are called to a hospital for an interfacility transfer, you need to make sure you get a full report about the patient's condition and you understand what they need from you. You need to make sure you can provide that level of care that they need. Make sure it's within your scope of practice. You need to make sure you have a signed, informed consent form for transport, and you have a written order for the transfer. And then you need to make sure you know what hospital you're going to and what the fastest route there is. An example of why this is important: if you were called to a hospital for a patient transfer, and say you're working on a BLS truck, it's you and another EMT basic, you don't have a paramedic, and you show up on scene at the hospital and the nurse says, all right, this patient's having a STEMI, a serious heart attack. Their blood pressure is 85/50, their heart rate is 150, and you look at the patient and they're gray, they're diaphoretic, the defib pads are attached to their chest. This would be a situation where you say, wait a second, they need a higher level of care for transport, and I can't provide them with the care they need. So some special situations that you might encounter, and likely will as an EMT, one of which is organ donation. And you might become aware on a call that your patient has designated themselves to be an organ donor. You might see it on their license saying they want to be an organ donor. What do you do with that information, and what are your responsibilities? First and foremost, just remember that they are your patient first and your organ donor last. And they will not be evaluated for donation of their organs until all life-saving efforts have been exhausted. So this is not up to you whether they're going to donate their organs or not. Ultimately, the hospital and family decide. So as your responsibility as an EMT, if you're made aware that someone is an organ donor, document it. Make sure if someone provides you with a license that says they're an organ donor, take that with you. And communicate with your medical director if you think that they would be a potential donor. Now, potential donors would be individuals who, their injury is compatible with donation. For example, the most common would be a fatal head injury. If they suffer a severe head trauma that's not going to be compatible with life, or they have a stroke. Other than that, your responsibility is just to perform normal care. If your medical director, may have you conduct CPR to maintain vital organs, to assist in harvesting. But first and foremost, just remember that, someone being an organ donor should not impact the care that you provide. Just let your medical director know and see if you have any additional instructions. Some patients will have medical ID bracelets, and these are, if you see these, you need to make sure you read them. They have very important information on them. They might tell you that that person has a severe allergy. It might tell you that they're diabetic, they have epilepsy, they don't want a blood transfusion. It might say they're on blood thinners. Sometimes they have a provider phone number you should call, or a specific treatment they may need in case of emergency. These can be necklaces, bracelets. Sometimes you'll find cards in people's wallets. As an EMT, you're going to be working really closely with law enforcement and the fire department, and there will be times that you will have to enter crime scenes to assess and treat patients. Just keep in mind that, while your first priority is for that patient and the care that you need to provide them, there is a low impact way to exist in a crime scene and not destroy evidence for future prosecution. So first, you just need to make sure the scene is safe, make sure law enforcement is on scene, it's safe for you to be there and safe for you to see that patient. Typically, you might have to sign into a crime scene and provide that information to law enforcement and take one way in and one way out so that you're not contaminating much of the scene. Only touch things that you need to. Don't go moving things you don't need to. If you have to move something, let law enforcement on scene know, I'm moving this, or I need you to move it for me. Don't take pictures. Your cell phone will become part of the crime scene and you'll never get it back. And make sure your report is thorough. Document everything you see. You may have to testify in court at a later date. And then when treating your patient, there's some special considerations to take. If you see if there's a gunshot wound or a stab wound through a piece of clothing, do your best not to cut straight through that hole and destroy the bullet hole or the stab hole through the shirt. Just cut around it. If you need to cut a rope, if someone was hanging or bound by a rope, try not to cut through the knot, cut away from it. And then if you're treating a patient who is a victim of sexual assault, ask them not to change their clothing, not to wash. Try not to give them anything by mouth to destroy the evidence, such as drinking water. And of course, you need to be respectful of that person and aware of the trauma that they just went through. So explain your reasoning for asking them to do these things. And of course, you can't force a patient to do any of these things. So just make sure that you're communicating with them to try not to destroy any evidence. There's sometimes that you have to report particular things that you might respond to. For example, there's mandatory reporting of child abuse and elder abuse. In some states, you have to report spousal abuse, but in North Carolina, you definitely have a legal responsibility that if you suspect child abuse or elder abuse, you have to legally report that to the authorities. Similarly, if you're on, scene treating somebody and then you realize that, wow, this is a gunshot wound or a stabbing or a suspicious burn or a poisoning or a sexual assault, you need to contact law enforcement and get them on scene and make them aware of that. Same thing for drug-related injuries. Make sure you get law enforcement on scene, not just because they need to know about it for the criminal investigation, but also for scene safety. If there's a drug-related injury or a crime that has occurred, you need to get law enforcement on scene. Some other things that you might have to report, suspected infectious disease exposures, and attempted suicides and dog bites. And you'll learn your local protocols and local laws about what you do and don't have to report to law enforcement. Another responsibility as an EMT is when you arrive on scene, you are going to have to make the decision of if it's appropriate to resuscitate a patient. if they do not have a pulse, they're not breathing, and are deceased. The really safe approach to this is if they're warm and there's no obvious signs of death, which are incompatible with life, which we'll talk about in just a minute, then you should resuscitate. In cases where they have a DNR, a do not resuscitate order, legally you have to abide by that, and you're not supposed to resuscitate. So you need to be able to recognize the presumptive signs of death. And with these signs, if they're present, you have good reason to believe that they're deceased. So the things that you look for, if they're deceased, there should be no pulse, there should be no breathing, no breath sounds. They should be completely unresponsive. They shouldn't be moving their arm or their toe or twitching. Should have no pupil response. If you were to take a blood pressure, they'd have no blood pressure and they would have no reflexes. Some of those obvious signs of death that I was talking about that are incompatible with life and are indicative that you should not resuscitate are decapitation, rigor mortis. And rigor mortis, if you look at this patient here, rigor mortis is, you would notice it when you try to move a patient. So if you try to move a patient and their arm is stiff, if you were to try to sit this patient upright, you would notice that there's a lot of resistance. The muscles are stiff, and it can be almost impossible to move patients when there's rigor mortis. This sets in within 2 to 12 hours after death. So if you see that a patient has rigor mortis, you do not resuscitate that patient. They've been dead for at least 2 hours, and those efforts would be futile. If you see any signs of decomposition, this can be, you can see it on the skin, you can smell it, sometimes the body will bloat, and those are also signs that someone has been deceased for a while. And then dependent lividity. This is a really important one to understand, and it's something that you can see pretty early on after someone has been deceased. But if this is present, they have been deceased long enough that resuscitation efforts are not appropriate. And you can see in this image here, if you look at this purple on this patient's arm and the purple on this patient's leg, that is blood pooling with gravity, and that's called dependent lividity. If that patient were laying on their back, you would look at their buttocks or you would look at their back, and you may see that same discoloration in those regions. On a lighter note, this is a good example of what not to do in a decapitation. All right, so let's go back to that case we talked about in the very beginning. This was the elderly male lying on the mattress on the floor with urine-stained underwear, foul odor, really cold environment, and his home was in shambles. There was garbage everywhere, boxes stacked to the ceiling, and his wife was really confused, and she also just looked really disheveled. You conduct your patient assessment, and you see that he's conscious, but he's disoriented. He complains of abdominal pain, but otherwise there's no signs of acute distress. You try to get the rest of your sample, but you're unable to obtain it from him or his wife. His wife doesn't even know his age, and she keeps asking you, are you her daughter? Are you my daughter? Are you my daughter? And then you try to ask her about her husband's medical history, but she really can't answer your questions. And then you're trying to take care of your patient, and then she keeps bringing up this porcelain doll collection and asking you if you're her daughter and do you want to play with the dolls. And it becomes really clear to you that neither her nor the patient is competent. You transport the patient, his condition remains unchanged. So what's your plan for this patient? What about his wife? And remember, we're talking about the legal and ethical responsibilities you have. So after you transfer the patient to the hospital, the right thing to do would be to contact social services. In this particular case, you thought that it might be a case of elder neglect. You have two individuals, your patient and the patient's wife, living in a home with unsafe living conditions, a cold environment, a dirty environment, unable to care for themselves. And you find out 2 weeks later that the patient had a gastric ulcer, but also an organic brain syndrome. And then his wife, she was also diagnosed with Alzheimer's disease. And both patients were moved to an extended care nursing home. Is there anything else that you could have done at the scene or at the hospital in this situation? One other thing I think I would have thought about would be trying to contact family. See if, they have a phone on them, and if you can ask them, hey, can I call your daughter? She keeps asking about her daughter. Maybe she knows her daughter's phone number. Maybe you can call the family and see if they have any more information that would be of use. All right, one more scenario to finish this out for the lecture. You have a 34-year-old female complaining of abdominal pain. When you arrive, you find the patient lying in bed, and she's alert, kind of rolling around in agony, holding her abdomen, and she says she's having really bad belly pain. You ask her when the pain started, and she said it started just very acutely 1 hour ago. You complete your assessment, place the patient on oxygen, and prepare her for transport. And then as you're preparing her for transport, she suddenly says, I don't want to go to the hospital. So what do you do? How do you initially gain consent from this patient? Remember, the first thing you need to do is make sure that she can provide informed consent, which means you need to explain to her what you found in your assessment, what you're worried about, and the potential risks of not being transported. So for this particular patient, I would be very worried. I'd be worried she has an acute intra-abdominal pathology. She could be bleeding in her belly. She could have a gynecological emergency. She could have a ruptured appendicitis. Her acute onset of severe abdominal pain is very concerning, and I would go as far to tell her that I'm concerned if I don't transport her, she could die. And then how do you manage the patient's refusal to be transported? Remember the steps. You need to try multiple times to convey your concerns to this patient. If you can't convey them, have your partner talk to her. Call your supervisor. Call medical direction if you need to. And if she still continues to refuse, what do? Document, document, document. You need to have a witness sign the refusal form and document that they witnessed the conversation and they witnessed her refusing your care. And then what would happen if you just decided, no, you are coming with me, and you tell her she can't refuse care and you do transport her? In that case, you would be committing false imprisonment and kidnapping, which would be a felony in North Carolina. So that's really not an option for this patient because she's competent, she can understand the risks of not receiving care, and she has a legal right to do so. So that's it for the lecture. Thanks everyone, and enjoy the rest of your day.